At the height of the civil unrest in Manipur, Assam Rifles, the paramilitary border security force guarding the state, has recently filed a sedition and defamation case against a civil society group, alleging they are instigating violence in the already volatile state. This has put the spotlight back on Section 124A of the Indian Penal Code that deals with sedition, a law that has remained controversial since its enactment way back in the colonial era. In this episode of Tête-à-Tête, we take a look at sedition law in India and its present status.
So, according to the section, whoever by words, either spoken or written, or by the signs, or by any kind of visible representation or otherwise, brings or attempts to bring into hatred or contempt. Or it also says excites or attempts to excite disaffection towards the government established by the law will be punished with imprisonment within 3 years up to life imprisonment as well. And they may also additionally be fined. So the phrase disaffection includes disloyalty and all feelings of the enmity. So basically, anti-establishment or any kind of anti-government is considered as sedition.
Right. A look at the genesis of this sedition law. Now, the sedition law was drafted way back in 1860 by Thomas Macaulay, a British politician and historian. Now, he is the author of the Indian Penal Code as it stands today in our country. This was primarily done with the intention of suppressing any voice of dissent against the then British rule in India. Now, the point to be noted is, though the law was enacted in 1860, it formally got incorporated in the Indian Penal Code only in 1870. Fortunately or unfortunately, it has remained since in the code. Now, the thing of sedition is it is a cognizable and non-bailable offense. Now, for the benefit of our viewers, we'd like to state that a cognizable offense is one where the police can make an arrest even without an arrest warrant. And hence, it is a non-bailable offense. You don't get bail very easily. Simply because the sedition law was designed in such a way that it is put on par with more serious offenses like terrorism, murder, rape, and so on and so forth.
Now, we need to first understand that Bala Gangadhar Tilak was the first Indian to be convicted for the sedition for his writings against the monarchy then. So, a sedition case was filed against Mahatma Gandhi in 1922 for his anti-colonial writings and protests against the British rule. So, he was convicted and imprisoned as well.
Over the years, there have been several landmark cases which have dealt with sedition per se. We'll look at some of the more important ones. In the Ram Nandan versus State of Uttar Pradesh case, the appellant was arrested on charges of sedition for making a protest speech amongst a group of villagers criticizing the then government for failing to curb poverty and deal with inflation. And as a result, he was convicted for prison to 3 years. On an appeal, the Allahabad High Court then held that Section 124A sedition was actually ultra vires of Article 19(1)A, which basically guaranteed freedom of speech and expression. In this issue, the High Court observed that any restriction should be reasonable and further held that any law should be enacted in such a manner that there is a proper balance between freedom of speech and social control.
So another important landmark case is the Kedarnath Singh versus the state of Bihar, which was in 1962, a Supreme Court case, similar to the facts which you had also presented. Here, the Supreme Court ruled that the crime of sedition can be established under the section of 124A only if the remarks or the words which are said or written have the potential, very, very important, which has the potential to disrupt or to disturb the public order through use of any kind of violence. Criticizing government does not mean spreading hatred or violence as long as it is a fair criticism.
Right.
So through this case, the Supreme Court restricted the scope of sedition.
Right.
And over the years, if you see, there have been several other cases which have echoed the same thought, and use of the sedition law to be done with lot of caution.
When it comes to sedition, over the years, the biggest challenge of it has been its increasing application by the government to people or anyone who's raising the voice against the government. Okay, it is more viewed as a tool to silence any dissent or protest against the government. In fact, there have been several instances of governments and even enforcement and regulatory agencies, police, ED, and everyone, falsely implicating people in cases and giving a hard time just to settle scores with them for raising a voice of protest against them. So, more than use, there has been more misuse of the sedition law, and that's why there's uproar about its continued existence in the IPC. As I was mentioning a little while ago about the furor that the sedition law has created, it has been the most discussed and debated section in the Indian Penal Code, I must say. There are varied views of why the sedition law must stay and far more views on why the sedition law must go. Okay. Yeah. So if we have to look at reasons why the sedition law is still in place and why it is favored as having to be continued, there is a general view that there needs to be a section to combat and deal with any anti-national secessionists who pose a threat to the security and sovereignty of the country. Further, there is a belief that this section will give the stability to any government, making them comfortable that there is no threat of a coup or them being overthrown, and hence they can function the way the executive has to function.
So, Sandhya, you had shared about why we need the sedition laws as such now. But I would like to also talk about that it requires to be abolished, the reasons why. So first is the provision as such has been enacted in the colonial British era as such. And since then, it has remained the same. And we have not changed anything or updated anything to the changing time as such. And the second aspect is the fear or the threat of the government to either rebuke or for any kind of action to be taken on any criticism which is made against the government rule, which will deter or suppress the voice of the common man. So this completely also violates the fundamental right to freedom and speech and expression under the Article 19(1)(a) of the Constitution as well. So fair criticism should be encouraged and it should not be curtailed as it acts as a reality check to the democratically elected governments as such.
Sure.
So freedom of speech and expression and the right to question, to criticize is the essence of the democracy.
Also, in the definition of sedition, if you see, there are some phrases like disaffection, which you had actually mentioned at the beginning of this episode. Phrases like disaffection are very general in nature, open to interpretation of any sort, and they're basically being ambiguous. There is no crystal clear meaning to disaffection. We did mention of it as enmity. So if you go under those phrases, then the arrests are most likely to be arbitrary only, right? So that is one reason, again, why either the definition must be amended or altogether it must go. Also, another point, which is most crucial, is there have been several arrests over the years under sedition cases. But if you have to look at the statistics, their conviction rates have been abysmal. They are very, very minimal. I can quote several cases. For instance, thousands, if you remember, thousands of people were arrested in the height of protests against the Citizenship Amendment Act. Okay. And similarly, hundreds to thousands of farmers were arrested when there were farm laws protests going on. Also, in a related case, I would like to state that a young environmental activist, she was arrested for under sedition for drafting documents allegedly which actually incited hatred and intolerance against the government. It was referred to as the toolkit case. Around that time, a little later, there was a young politician couple who were actually arrested under sedition law for wanting to chant a religious hymn in front of the chief minister's office. They were arrested under sedition, citing inciting religious intolerance. It was ironical, but they were. So all of these cases, and there were several more to name, but these are something that I could actually think of.
Adding on to what you have said, I must also say that a political cartoonist was jailed under the sedition law for drawing satirical cartoons on corrupting depicting the parliament. So in all these cases, sedition could not be proved and hence there was no conviction. So in fact, in 2019, the statistics clearly shows that there are about 93 cases which were filed under the sedition. However, there was only one conviction which was done. So this only clearly shows that the complete misuse of the sedition law.
Right. In May 2022, while dealing with a bunch of petitions, especially in the S.G. Bombatkare versus Union of India case and similar other petitions, the Supreme Court passed a historic order. It is in fact viewed as a historic order, but a temporary order, directing the government to keep in abeyance all cases of sedition till the government re-examined, reconsidered the continuation of this law. Now, essentially what that meant is all pending trials of sedition were suspended and no new cases could have been taken up. It was considered a historic, it was a temporary interim order because the Supreme Court directed the central government to re-examine and review the continuation of the sedition law.
So in June this year, the Law Commission had submitted a report recommending the continuation of the sedition law, but with several procedural and other amendments put in place. So it merely stated that because a law is colonial, it cannot be abolished, as its purpose and objective also must be kept in mind. And also because a law is being prone to being misused, it cannot be abolished. Procedural amendments such as verification by police and submission of the reports to the government precede any arrest and trial under the sedition. So the term for the punishment also increases from 3 years to 7 years or life imprisonment now. And other laws such as the UAPA, National Security Act, may also not address the specific issue offense like in the Sedition Act.
There have been mixed reactions to the recommendation of the Law Committee suggesting the retention of the Sedition Act but with procedural and other amendments. A larger section of the legal fraternity is of the view that the archaic and the colonial era act law must go. While the intention of the Honorable Supreme Court is, praiseworthy because they have put in abeyance, effectively suspending all the pending trials, one has to wait for the final acceptance of the Law Committee's recommendation and eventually the final decision of the Honorable Apex Court. We hope our viewers found this edition informative. We'll be back with more in the next edition. Thanks for watching.